Hey all, I'm Richard Burnham, aka The Indie Lawyer, and welcome back to my series Lawvel 101, where today we're asking, what exactly is intellectual property? Intellectual property is a massive topic, so it's hardly surprising that it's also massively misunderstood. But unhelpfully, it's also very easy to flamingo up or give it away without meaning to, so it's crucial as a game developer that you understand the concepts behind intellectual property and take the basic steps to protect your games as you go through the development process and ultimately beyond. In this first video, we're going to rattle through what intellectual property actually is and what types you can find. So what exactly is intellectual property? Well, a lot of people get the general idea behind it, but they're not sure exactly how it works legally or what steps they need to take to be under its protection. Now what it essentially is a way of protecting the stuff that humans create from being copied or exploited by other humans. What you're basically saying are, these are my words or these are my shapes and you can't use them. It's a bit of a bizarre concept really, because it's limiting things that are usually freely available to the entire human race, like our language. It's basically me saying, you can't use these words in this particular order or I'll sue you. Now essentially the point is to reserve the right to sell and commercially exploit your ideas. So basically, if I create something like this, you can't take it and sell it to other people or pretend you created it unless I give you my permission. Obviously this is, probably the copyright or trademark of Nintendo, so not suggesting it's mine. Intellectual property law protects a number of things: shapes, words, designs, the function of a particular system, and even computer code. You can basically break what IP protects down into 4 categories: business interests, creative expressions, designs, and inventions. But we'll be focusing on business interests and creative expressions as game developers. Intellectual property law is a little fragmented across the globe, so in each individual video we'll look at to what extent a global position exists for each type of intellectual property. So why should you care about intellectual property? Well, it's a good question. Intellectual property is massive for game development. Games are, after all, the moneymakers for our studios at the end of the day. And intellectual property tends to make up the majority of a game company's value as a result. Intellectual property is like any other form of property. It's got value, it can be sold, bought, licensed, and even used as security for a loan. Because it's so important to a studio, it's vital that you're on top of who exactly owns your IP, and when you're dealing with publishers, making sure you're not giving too much away. There are a number of intellectual property rights out there, including database rights, plant varieties, moral rights, performance rights, and even semiconductor topography, which has something to do with computer chips, but I won't pretend to understand what that is. We'll put them to one side for the moment because they're not really relevant to game development, unless you're making something very funky. To begin with, I'll be focusing on the 4 main ones that relate to game development: copyright, trademarks, passing off, and patents, or patents, whatever. Let's take a quick look at each of these before we dive into the first video. Copyright is probably one of the most powerful weapons in a game developer's arsenal. I'll go over it in detail in my next few videos, but it basically exists to protect against creative expressions like a game's storyline, the designs of characters, the code that powers the game, and even its music. So it covers basically a massive part of what actually goes into a game. Now, a key part of copyright is it doesn't exist for ideas that are inside your head. You actually have to express the idea before copyright will protect you. You do this either by drawing the character, typing the script, writing the music. You just got to get it out there first. So if you told me about a great idea for a stick superhero character you had, and later on that night I went home and drew him, it's mine. It's not protected if it's inside your head, even if it is fantastic art, and I'm sure you'd just give it to me anyway. Now in the UK and most jurisdictions, we work on an unregistered system, meaning anyone who copies your work is in violation. You don't actually have to do anything to be covered by copyright, and you're usually covered for 70 years from the date of your death. Something to think about. A trademark is a name, logo, or any kind of mark which consumers tend to associate with a particular brand. For example, if you purchased a Pokemon game with the Nintendo logo on the front of it, you'd be fairly happy that was a product of Nintendo. Now, having a registered trademark allows you and you alone to use that mark when producing and selling games, and it's a crucial way of allowing your customers to properly associate your games with your studio. Now, trademarks are usually capable of being protected indefinitely, provided whatever is being trademarked complies with the registration rules. But in most jurisdictions there are 2 types, registered and unregistered, but we'll discuss that in more detail in the particular video. If someone uses your registered trademark without your consent, you can file proceedings for trademark infringement, which from a legal point of view is fairly straightforward. And it's therefore quite a powerful tool to have in your locker if you find someone using your logo, name, or anything else that you've trademarked without your consent. Passing off is kind of a similar intellectual property right to trademarks, and it's sometimes referred to as an unregistered trademark just to make things even more confusing. It's essentially an IP right that stops other people trying to piggyback or take advantage of your business's reputation, for example, pretending to be your game studio or selling games that are deliberately designed to be similar to yours with the intention of misleading consumers. The right applies even if you don't have a registered trademark, although passing off is much more difficult as a claim to bring an infringement for a trademark for reasons we'll discuss later. And in the legal world, more difficult usually means more expensive. Patents exist to protect inventions and processes, and can generally be anything which has some kind of inventive or industrial application, providing it's bringing something new to the table. A patent gives its owner the exclusive right to exploit the technology commercially for 20 years' time, after which point it enters the public domain and comes up for grabs for anyone to use. The logic behind this is it's better for humanity as a whole for the patent to eventually become usable by the public, but it gives the creator a generous 20-year period to make money from it first. For example, if I created a life-saving drug, it's arguable that 20 years is long enough for me to profit from it before humanity as a whole should gain access to the information within the patent. I'm going to put patents to one side for the time being, because game software isn't always patentable, and the law across the different jurisdictions is a bit of a mess at the moment. It's currently up for debate whether games are patentable or not, because a patent requires some kind of technical and new contribution, which isn't always satisfied through computer-based inventions, particularly where there's no physical component. As a really basic analogy, the issue is essentially that writing code isn't always necessarily something novel or inventive, because coding already exists. It's more relevant if you're making some kind of physical game technology that complements your game. Think, for example, the Guitar Hero controllers or the Poker Walker that came with Pokemon Soul Silver and Heart Gold. Patents are always horrendously expensive and time-consuming, so they're not something that's usually on the radar of indie developers, but maybe something to keep in mind for the future. I'll say, there will be a video on it, but it's not first on the list at the moment. So that was a lightning round review of the different IP rights that typically apply to game development. In the next video, which will be a two-parter, we'll be taking a look at copyright, focusing on what game assets copyright protects, what you need to do to ensure your assets are copyright protected, and what you need to do if they're infringed. So until next time, I'm the Indie Lawyer. Catch you later.